Let us pray. Almighty God, we willingly acknowledge you as a supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth, and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Announcements by the President.
Honorable Senators, I have granted leave of absence to Senator the Honorable Jennifer Batiste Primus, who is out of the country. Honorable Senators, I have received the following correspondence from Her Excellency the President Paula May Weeks. The Constitution of the Republic of Trinidad and Tobago by Her Excellency Paula May Weeks, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces. To Mr. Garvin Simonet. Whereas by instrument dated the 28th of May 2018, I appointed you to act as a temporary senator with effect from the 29th of May 2018 and continuing during the absence from Trinidad and Tobago of Senator Dr. Lester Henry. In exercise of the power vested in me by Section 44 of the Constitution of the Republic of Trinidad and Tobago, and acting in accordance with the advice of the Prime Minister, I, Paula May Weeks, President as aforesaid, do hereby revoke with immediate effect your appointment to act as a temporary senator, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's this 4th day of June 2018. To Ms. Alicia Romano. Whereas Senator the Honorable Jennifer Batiste Primus is incapable of performing her duties as a senator by reason of absence from Trinidad and Tobago. Now, therefore, I, Paula May Weeks, President as aforesaid, acting in accordance with the advice of the Prime Minister, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Alicia Romano, to be temporarily a member of the Senate with effect from the 5th of June 2018 and continuing during the absence out of the country of Senator the Honorable Jennifer Batiste Primus, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's this 4th day of June 2018. To Mr. Ndale Young. Whereas Senator Dr. Lester Henry is incapable of performing his duties as a senator by reason of absence from Trinidad and Tobago. Now, therefore, I, Paula May Weeks, President as aforesaid, acting in accordance with the advice of the Prime Minister, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Ndale Young, to be temporarily a member of the Senate with effect from the 5th of June 2018 and continuing during the absence out of the country of Senator Dr. Lester Henry, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's this 4th day of June 2018. Honorable Senators are required to take the oath.
I, Alicia Romano, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, Ndala Young, having been appointed a member of Parliament, do solemnly affirm that I will bear true faith and allegiance to Trinidad and Tobago and will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibility to the people of Trinidad and Tobago upon which I am about to enter.
Bills brought from the House of Representatives, petitions, papers.
Acting Leader of Government Business.
Madam President, I have the honor to lay on the table the following papers as listed on the order paper in the name of the Minister of Public Administration and Communications. The 107th report of the Salaries Review Commission of the Republic of Trinidad and Tobago in relation to the Office of Director Maritime Services, Ministry of Works and Transport.
Reports from committees.
Acting Leader of Government Business.
Madam President, I have the honor to present the following report on the supplemental order paper in my name. The report of the Joint Select Committee appointed to consider and report on the Anti-Terrorism Amendment Bill 2018. I thank you.
Urgent questions.
Senator Obika.
Thank you, Madam President. To the Minister of Education, in light of reports of the University of Trinidad and Tobago's pending closure of some of its campuses, can the Minister indicate which campuses are earmarked for closure?
Minister of Education.
Thank you very much, Madam President. Madam President, as far as I'm aware, and as far as the government of Trinidad and Tobago is aware, no decision has been taken at this time to close down any of UTT's campuses. What one might have read in the newspaper is merely speculation. However, there are some campuses where some changes have been made, and I will be happy to share with you some of these changes that have been made. But let me reiterate, at this time, no decision has been taken to close down any of UTT's campuses. Thank you.
Next question, Senator Mark. Sorry?
Sorry, I was trying to get a follow-up to the
Sure.
question.
Senator Amin.
Madam President, just to clarify, because in the past we had an issue like this, I appreciate the Minister's response that no decision has been taken to close any campuses. Is any such thing under consideration at this time?
Minister of Education.
Madam President, there are considerations that are being examined now by the UTT with respect to restructuring its operations. And when those discussions have been completed in the fullness of time, we'll be able to reveal to you what are the necessary changes that might be put in place. Thank you very much.
Senator Amin. Senator Ramdeen, sorry.
Thank you, Madam President. Madam President, through you, having regard to the Minister's response, with respect to the changes that are proposed that were referred to by the Minister, could the Minister kindly inform the Senate how many employees would be affected in the different campuses to which these changes are directed or proposed?
No, Senator Ramdeen, I won't allow that question. Next question, Senator Mark.
To the Honorable Minister of Works and Transport. Given reports of the possible blacklisting of the Port Authority by the United States authorities for its failure to settle outstanding salary arrears owed to Port Police, can the Minister indicate what measures are being taken to avoid this situation?
Minister of Works and Transport.
Madam President, let me firstly say that I have no information that there's a possibility of blacklisting of the Port Authority by the United States Authority for its failure to settle outstanding salary arrears. However, Madam President, at this time, the management of the Port Authority is in communication with the Office of the Chief Personnel Officer to come to a negotiation position in which the Port Authority can engage the Estate Police Association. Those discussions are expected to commence this week. Thank you.
Senator Mark.
Madam President, could the Honorable Minister indicate to this House, Senate, what is the quantum of outstanding arrears of salary owed to the Estate Police of the Port Authority? We are not talking about no new negotiations. Outstanding arrears.
Minister of Works
Thank
and
you.
Transport.
Madam President, on the eve of the 2015 elections, and I'm talking about, I think it's the day before the elections, the Port Authority Board and the Estate Police signed an agreement. However, it was not approved by the CPO, and the percentage increase was the maximum of 14%. However, this was not approved in keeping with the process by the CPO. And that is what is being calculated right now, and that is what is before the CPO. Until that part is not finalized, a quantum cannot be established of the outstanding. Unfortunately, the negotiations were tried to fast track the day before the elections, not in keeping with proper negotiation procedures. Thank you.
Senator Mark.
Can the Honorable Minister indicate whether the agreement has been properly signed by the parties involved, the union and the Port Authority management, and how many workers are affected?
No, two questions. Those are two. So ask one, please.
Yeah.
Whether it's properly signed? Yeah.
Could you indicate to this House whether the agreement has been properly signed off by the relevant parties involved in these negotiations?
Minister.
Thank you, Madam Chairman. Sorry, Madam President. Both parties signed. However, it was subject to the approval of the CPO. So, as a layman and based on the advice of the attorneys, unless the CPO does not agree, we do have legal questions about the agreement. Thank you.
Next question, Senator Mark.
To the Honorable Minister of Health, given conflicting reports alleging that a patient committed suicide at the Mount Hope Hospital last week Friday, can the Minister indicate what is being done to ascertain the facts?
Minister of Health.
Thank you very much, Madam President. Madam President, before I get into my answer, it is incumbent upon me to offer deepest condolences to the family of this patient. It is somebody's father, brother, uncle. However, I have a duty to the health system and the population to speak facts as far as non-disclosure of patient confidential information is concerned. I will therefore read a press release which was sent out yesterday, titled NCRH's Duty of Patient Confidentiality, June 4, 2018. The NCRH wishes to express its concerns as it pertains to misinformation surrounding the death of a patient at the Eric Williams Medical Sciences Complex on June 2, 2018. It is very concerning to the NCRHA that the statements that are being reported in the media. As we continue to improve for the benefit of the public, it is imperative that we maintain patient confidentiality. In this regard, we wish to inform the public that the NCRHA takes seriously its duty as it relates to patient information. As such, we are unable to divulge all the information regarding this incident, even if by doing so, we can clarify or correct misinformation about this incident. We are, however, at liberty to state the following facts. At approximately 3:40 a.m. and in full view of witnesses, inclusive of patient and staff, and we have witness statements, the patient in question broke through a glass louver window to land in the outer corridor of an inpatient ward after exhibiting violent and aggressive behavior. The patient then threw himself over a banister on the second floor before nursing and security team could grab hold of him. The authority continues to operate under its duty.
I'm sorry, but your time is up. Senator Mark.
You can circulate the rest. Madam President, through you, could the Honourable Minister indicate, in light of what appears to be conflicting information arising from this incident, has the North Central Regional Health Authority, through your ministry, launched an official inquiry into those circumstances?
Thank you very much, Madam Speaker. Madam President. The way to do this, and as I was going to say, is for the patient's family to agree in writing for the Ministry of Health to divulge the additional information of the patient. We cannot tell the public, even under the cover of parliamentary privilege, what this patient was suffering from. We ask that the patient's family allow us to clear up the misinformation based on the facts that we have it, which will tell the country what the patient was suffering from, what he was diagnosed with, and what we were doing to treat this patient. In the absence of that, it will continue to be allegations, and we ask next of kin to give us that permission, which will tell the country the true facts surrounding this case. Even as we condole with the family, we have a duty of care to the public health system to protect its integrity. Unless the patient's family does that, we have to accept that body blow. And that is an unfortunate thing. People can make allegations, but because of patient confidentiality issues, because there's a patient charter which speaks to dignity and confidentiality, we cannot respond to those allegations, even under the cover of parliamentary privilege. So I urge the next of kin of this patient to give us in writing permission to tell the country what this patient was suffering from and why he may have behaved in that particular manner. I thank you, Madam President.
Senator Ramleen.
Under section 4 of the Constitution, under the right to life, a public institution has a duty, an implied duty.
You have to ask the question.
I'm going to ask the question, Lady. I'm just laying the foundation.
Yeah.
To set up an independent inquiry by an independent person to inquire the facts.
Senator
I would like to
Ramleen,
ask the Minister,
yes, ask the question,
whether any independent inquiry has been, well, I get the answer from the Attorney General.
Could you just
before.
ask the question? I will deal with whatever is happening. You're asking whether there's an independent inquiry.
Whether an independent inquiry has been set up to ascertain through the institution the facts, notwithstanding any permission from the next of kin.
No, Minister, the time for urgent questions has expired, and that is why I encourage members to be very direct with your questions. Okay? So the time has expired.
Questions on notice? Questions for oral answer?
Acting Leader of Government Business.
Madam President, there are 7 questions on notice. The first 4 of those questions, Madam President, were previously deferred, and the government is prepared today to answer 2 of them. Those are number 131 and number 133. There are 3 other questions on the order paper, Madam President. The government is prepared to answer today number 138 and 139, and we are respectfully asking for a deferral of question number 137 to the Minister of Works and Transport. Thank you.
For how long, Leader? Government
Madam
Business?
President, for 2 weeks.
Question number 137 is deferred for 2 weeks. Senator Mark. Question 131.
Question 131 to the Minister of Works and Transport.
Minister of Works and Transport, you have 5 minutes.
Thank you, Madam President. Madam President, I am advised that assessment by a UK-based company of the 2 passenger ferries were commissioned by an insurance company in 2016 and 2017 for the sole purpose of establishing the insurance risk associated with the ferries in order to settle the terms and conditions of the contract for insurance for these vessels and the insurance premium. I am further advised that these reports have never been officially made available to the Port Authority or the Ministry of Works and Transport and do not reveal multiple defects to the vessel. Most importantly, Madam President, it must be noted that the vessels are classified by the DNV Classification Society, which determines the seaworthiness of the vessels to continue in operation. In this context, both ferries have been valid class certifications up to the time of their withdrawal from service for the purpose of dry docking. I thank you, Madam President.
Senator Mark.
Madam President, in light of the fact that this report was conducted by an insurance company to determine, for purposes of insurance, the continuation of coverage, can the Minister explain to this House how he became aware that the vessel in question did not suffer from multiple defects?
Minister.
Madam President, again, the vessels are inspected by DNV Classification Society. All indication is that the vessels would have been classified up to the time of dry docking. I became aware of the article in the newspaper, of which I asked for a full investigation. What was sent to me by the Port Authority is a letter from the insurance company indicating that they did the inspection, as I said before. However, that was not made a part of the official documents of the Port Authority. Thank you.
Senator Ma.
Madam President, could the Honourable Minister indicate whether the Port Authority or his ministry had any access to this particular report, which was published in the newspapers by this UK-based firm?
Minister.
Thank you, Madam President. After reading the article in the newspaper, I called for a report. It was indicated by the insurance company that unofficially they gave 2 managers of the port copies of the report, which were never tendered to the board nor the ministry. It did not become part of the files at the Port Authority. However, those 2 managers are no longer employed at the Port Authority. Thank you.
Senator Mark.
Madam President, would the Minister be prepared to make a copy of the report which was submitted to him by the management of the Port Authority based on his request on the newspaper report concerning defects surrounding this vessel. Would you be prepared to lay that report?
Minister.
Madam President, I'm quite prepared to lay the response I got from the port together with the letter from the insurance company where they would have submitted those 2 reports unofficially to 2 senior managers and were not made part of the archives at the Port Authority. And as I said, those 2 managers are no longer employed with the Port Authority.
Senator Ma.
Madam President, can the minister give this House a time frame or a timeline for the tabling of the report along with the documentation that you have outlined?
Minister.
Madam Speaker, Madam President, what I will willing to submit to the port is the report that I got from the port. As I said before, that report is not a document prepared for the Port Authority, and it does not form part of the official document. I will give an undertaking to provide the report as per the request from the Port Authority as for the information based in the newspaper article. Madam Speaker, I could get that ready for the next sitting of the Senate.
Next question, Senator Mark.
Have I exhausted my...
Yes, you have.
Oh, I see, sir. Time, we here for a long time. No, I am being guided by the President, not Paula Gopisco, or Senator the Honorable, the Minister, I should say. Madam President, may I address you properly speaking?
That would be nice.
Yes.
Yes.
Focus, and you see how I've turned, Madam President.
Yes, Senator Mark. Next question, please.
Yes, Madam President, question 1. No, I have to go on. Madam President, which question do you have?
133.
133. Thank you, Madam President. Madam President, question 133 to the Honorable Minister of Works and Transport.
Minister of Works and Transport.
Thank you, Madam President. Madam President, we could have taken all these questions into one. Madam President, I am advised that the report being referred to did not indicate that the TNT Spirit had been operating in an almost unserviceable state. Madam President, this question is not anchored in facts, and it is very unfortunate that the process of Parliament is being used to create public mischief. I am advised that the report in question was a confidential commercial document produced for the insurance of the vessels. Moreover, having regard to the fact that the report was not formally submitted to the commissioners of the Port Authority or to the Line Ministry, legal advice must be sought to determine whether any action can be taken against anyone. Further, Madam President, on the advice of the Port Authority and the Maritime Service Division, the TNT Spirit was sent to dry dock for a comprehensive overhaul and has since returned to provide good service to the sea bridge. The Port Authority, in keeping with its maintenance policy, continues regularly and preventative maintenance of the vessel as part of the standard operating procedures. In addition, the Ministry of Works and Transport is putting the necessary arrangement in place to ensure that the issue of past relating to the maintenance of the vessel in Trinidad and Tobago are rectified on a long-term basis. I thank you.
Senator Mark.
Madam President, I would like to ask the Honorable Minister a direct question. Are you accusing the relevant newspaper that published this report of being engaged in public mischief, and therefore action by the government is pending against this particular newspaper?
Minister.
Let me just read back something. Madam President, this question, unfortunately, that the proceedings of Parliament, I'm accusing certain parliamentarians, not the newspaper, because the article said the deficiencies that the insurance company saw to prepare their insurance premium. They did not say that the vessel should be taken out of service. The DNV classification is what allows the vessel, and once DNV is not satisfied on safety of the vessels will be immediately asked to be withdrawn. That did not happen.
Madam President, with your leave, I call on the minister to either identify the parliamentarians that has engaged in mischief, or you withdraw, the honorable minister that is, immediately, unconditionally, unreservedly withdraw, because you are casting aspersions on every parliamentarian in this house. Either you identify the parliamentarians involved or you withdraw that statement. Madam President, I ask you, because that is imputing improper motives to every member of this Senate at the South and the other place. Please get the minister to identify the parliamentarians or withdraw that statement. I ask for your intervention in this matter. He's imputing improper motives to us, Madam President.
Madam President, I have answered several questions in this House and the other House about the Port Authority, and the questions continue to be coming in such a way to get something out from the minister that does not exist. However, if the minister and the senator feel that Senator Mark feels, maybe in a different country, However, if the senator feels that I have offended him or any other senator, I withdraw. Thank you.
Right. Good. Next question, Senator Mark.
Yeah, because
Senator Mark, just direct the question to the relevant minister. Please,
Madam
the next
President,
question.
I'm now trying to exhale
Yes.
before I can speak. Because I couldn't catch myself. I'm catching myself. So please allow me. Madam President, I'm to 138, ma'am?
Yes, you are.
Thank you very much. Question 138 to the Honorable Minister. That's a very decent job.
Senator Mark.
Minister of Rural Development and Local Government. The Honorable Minister of Rural Development. Question number 138. Sorry, Madam President.
Minister of Rural Development and Local Government, you have 5 minutes.
Thank you very much, Madam President, and thank you, Honorable Senator, for your question. The Pinal-Debe Regional Corporation has advised that it's embarked on a three-pronged strategy to mitigate the health risks being posed by clogged drains in the region. Routine cleaning and clearing of clogged drains under its remit. Since the beginning of 2018, the corporation has intensified its commitment to cleaning and desilting drains, which will affect flooding and associated health hazards, by augmenting the manpower and programs under its public health department. As a result, the corporation has cleaned and desilted more than 1,000 meters of drain in the Debe district to date. Monitoring of drains condition in the region and enforcement of the appropriate legislation and bylaws carried out by municipal corporation. A legislative and by-law enforcement initiative has been embarked upon, targeting flood-prone areas where wanton breaches occur with respect to the provisions of the Municipal Corporation Act 2504 and the Public Health Ordinance Chapter 3907 and the Litter Act Chapter 3552. The litter wardens have been playing a major role in this area by issuing tickets to individuals who have infringed the Litter Act Chapter 3552 as amended. As such, during the period 2017 to April 2018, the following notices and orders have been issued to individuals in breach of the Act. 29 fixed penalties notices were issued to persons for illegal dumping at the Gandhi Village site, M2 Ring Road, Laramine, where illegal dumping frequently occurs, 49 cleanup orders, and 40 litter removal orders have been issued. 19 litter removal orders were issued for derelict vehicles. Education and public sensitization campaign. The corporation is in the process of implementing an educational and public program regarding drainage, flooding, and development planning control issues within its region. The program is intended to educate the residents, institutions, and stakeholders within the region on the laws, bylaws, and regulations pertaining to building properties, filling of land, littering and dumping, and how these actions compound the issue of flooding in this region. In addition, each municipal corporation, regional coordinating committees are established to ensure efficiency in the management of operations and coordinating of delivery of services. As such, the committee ensures there is coordination and collaboration among the relevant agencies responsible for the execution, expansion work, and maintenance in the respect of drainage and infrastructure. Thank you, Madam President.
Senator Ma.
Madam President, the Honorable Minister indicated to this House whether the particular drains in question that I identified in the penal area, have they been addressed in terms of being on club, particularly in light of the pending rainy season?
Minister.
Thank you, Madam President. I have a list of all the drains that were cleaned, and these drains have been cleaned every 3 to 4 months according to the program of works. I have the exact amount of money spent every month and the manpower used for these drains. I don't know if I should call the name of the okay, I have them here and I'll circulate them. Thank you very much.
Next question, Senator Mark.
I'm getting back at you, Mr. Minister. I'll be at you all the time until I move you.
Senator Mark, please.
Sorry, Madam.
Yeah, I know. I know.
That's between both of us. You know,
Yes,
that's my friend, you know.
but if it is between both of you, then take it outside. But I'm not. But I'm not. I do not. Senator Mark, please.
I understand you,
yes.
I understand you. I'll take it outside. On the pavement. Thank you, Madam President. My friend is all exhilarated. I don't know what is the exhilaration about. Madam President, may I ask this question now through you?
It's question 139, Senator Mark.
Madam President,
in all of your exuberation and exhilaration, you losing focus. Question 139 to the Minister of Works and Transport. There, I've done it for you, Minister of Works and Transport.
Thank you. Thank you very much, Madam President.
Senator Mark is my friend, and in 2013, when he was supposed to be the President of the Republic, I was going to the swearing-in, you know. when he bought the suit to be sworn in just before they changed their mind, I was going to be there. Madam President, I'll get back to the question. Madam President, the safety of the drivers and the cargo is of paramount importance. In light of these measures, for vehicles waiting to board the cargo star leaving for Trinidad and Tobago, the following is in place. The truckers using the MV Cargo Star, which is located at berth 3, are required to access the vessel along dock road. The loading of the vessels may at times result in a queue. At this area, there are security officers stationed at dock road within the cruise ship complex and at the ramp at berth number 3. There are also 2 security officers on the vessel during each sailing. Cargo operations, bulk cargo, pallets and flatbeds are placed on the vessel. In addition to the security in the operation space at the cruise ship complex, there are security personnel on the ramp where the cargo is being offloaded from trucks and vans. I thank you, and I wait your supplemental.
Senator Mark.
Madam President, Honorable Minister, you would have known about a recent incident involving a trucker whilst they were waiting to board the Cabo Star. Could you share with this Honorable House what additional measures have been introduced in order to tighten security whilst these truckers are awaiting boarding of their vehicles on the Cabo Star?
Sure. Thank you. Madam President, the incident referred to by Senator Mark is an incident that happened along Ryson Road, where the National Police is responding to activities, and consultation have been taken with the National Police. Whenever there's a queue extending all the way to Ryson Road, that additional security is mobilized for the truckers. Thank you.
Request for leave to move the adjournment of the Senate on definite matters of urgent public importance, statements by ministers or parliamentary secretaries, personal explanations, introduction of bills, motions relating to the business or sittings of the Senate, and moved by a minister.
Acting Leader of Government Business.
Madam President, having regard to the correspondence from the Deputy Speaker of the House in relation to the establishment of a joint select committee to consider and report by July 31st, 2018 on the Trinidad and Tobago Revenue Authority Bill 2018, I beg to move that the Senate concur with the House of Representatives in the establishment of the committee and that the following 6 senators be appointed to serve: Mr. Franklin Khan, Ms. Alison West, Mr. Robert Lehunt, Mr. Wade Mark, Mr. Torrell Shriki-Soon, and Ms. Jennifer Raful. Thank you.
Honourable Senators, the question is that the Senate concur with the House of Representatives in the establishment of a joint select committee to consider and report by July the 31st, 2018 on the Trinidad and Tobago Revenue Authority Bill 2018, and that the following 6 senators be appointed to serve: Mr. Franklin Khan, Ms. Alison West, Mr. Robert Lehunt, Mr. Wade Mark, Mr. Torrell Shriki-Soon, Ms. Jennifer Raful. Those in favour say aye.
Aye.
Those against say no. The ayes have it. Acting Leader of Government Business.
Thank you, Madam President. Madam President, having regard to the correspondence from the Deputy Speaker of the House in relation to the establishment of a joint select committee to consider and report by June 30th, 2018 on the Income Tax Amendment Bill 2018, the Mutual Administrative Assistance in Tax Matters Bill 2018, and the Tax Information Exchange Agreements Bill 2018, I beg to move that the Senate concur with the House of Representatives in the establishment of the committee and that the following 6 senators be appointed to serve: Mr. Clarence Rambarat, Mr. Lester Henry, Mr. Daniel Duki, Mr. Saddam Hussein, Mr. Stephen Crease, and Mr. Paul Richards. Thank you.
Honourable Senators, the question is that the Senate concur with the House of Representatives in the establishment of a joint select committee to consider and report by June the 30th, 2018 on the Income Tax Amendment Bill 2018, the Mutual Administrative Assistance in Tax Matters Bill 2018, and that the following 6 senators be appointed to serve: Mr. Clarence Rambarat, Mr. Lester Henry, Mr. Daniel Duki, Mr. Saddam Hussein, Mr. Stephen Crease, Mr. Paul Richards. Those in favour say aye.
Aye.
Those against say no. The ayes have it.
Public business, government business, bills second reading.
Attorney General.
Madam President. Madam President, before I begin, is it that the Senate has agreed to do all of these 4 related bills together? No. Senator Mark? Sorry.
No.
No. Okay. Thank you. Madam President, I beg to move that a bill entitled An Act to Amend the Registration of Titles to Land Act 2000 be now read a second time. Madam President, I took the caution to ask that question a short while ago because before us on the order paper, without breaching the rules of anticipation, are 4 intimately intertwined bills which sensibly should be managed together. And in fact, in the history of this particular amendment to this particular bill,
when the land package, as it was referred to, was laid in 1999 by then Attorney General Ramesh Lawrence Maharaj, all of the legislative measures were taken together because there's a fluidity in it. So, such is the desire of the Senate and apparently the dictates of the opposition, we will proceed. Madam President, the government is very pleased to carry forward much needed amendment to the land laws of Trinidad and Tobago. Let me put it in very simple terms. Land, as everyone knows, is a definite resource, particularly when one occupies an island state of two beautiful islands as we do between Trinidad and Tobago. It is a resource which identifies history, wealth, continuity. It is the very land which we stand on and the land under our seas which provide us the manner in which we live, be it exploitation of oil and gas or fishing or agriculture. The fact is that for generations, each of us as we came here learned to pride land. Regrettably, however, the management of our land resource has been something which has been stuck in a time warp. Land as a resource has now fallen into a very significant issue, and that is corruption. Land is one of the definite resources which relates to some of the other problems which we face in this country, which is crime and criminality. Because if the system of registration of land is not a proper and transparent system, if it is open to abuse and influence, improper influence, you can find land and the mechanism for registration of land being used to hide the proceeds of crime. That's a very significant issue for our country right now. Trinidad and Tobago is wrestling and has been wrestling for quite some time with the issue of criminality. And in pursuit of the government's agenda to deal with corruption as it feeds the monster that is crime, this package of laws and this bill that we seek to have support for is directly associated with that. So for the listening public, let me put on record that our system is definitely an archaic system. Effectively, Trinidad and Tobago manages its land resource under two pieces of primary legislation. The first one is the Registration of Deeds Act, Chapter 1906, which is Act number 18 of 1884. That is now 174 years old. The second principal piece of law that we treat with our land resources on is the Real Property Ordinance, Chapter 1201, as it was before it became the Real Property Act, Chapter 5602. And that law was brought to Trinidad and Tobago in 1892, and it now stands 126 years old. We inherited in the 19th century the English law. Attached on to the two laws that I've mentioned, of course, is the Conveyancing and Law and Property Act, which was brought into effect in 1845. It's now 173 years old. And we also, of course, have the person who manages, the entity which manages land in the structure of the Registrar General, which is Act number 1903, which is an Act number 49 of 1921. Effectively, in the 19th century system of law, land as it came to our country, brought through the English feudal system, was that and still is all land which is not allodial land or land which is free of the state. All other land belongs to Norman the Conqueror, as he conquered the English dominance and domains in 1066. And a feudal system of land management was invested and inherited and managed and passed on, such that the kings of England owned all of the lands, seas, animals, beasts, whales, etc. And they in fact gave title by way of tenancy in chief and then title in tenancy in common. Tenancies in chief were given to landlords, and tenancies in common were given to folks of lesser status in society. Simplifying that position, fee simple land. And fee simple land is land which can be inherited and which comes from the king. And this now stands as the closest evidence of what is absolute ownership in the laws of Trinidad and Tobago. This system differs completely from the model which prevails in the European system or civil law countries where there is a concept of absolute ownership. So we have in this system of fee simple land two structures which flow from that. You can have freehold title, meaning that you pass on land without covenants in a strict form where you don't have to have a landlord or a reversion resting somewhere else. And we have leasehold land. And into these two types of arrangements, freehold and leasehold, we flow the two systems of registration. Firstly, under the Registration of Deeds Act. Secondly, under the Real Property Act. The Registration of Deeds Act, however, as it came first in time, is risky. Under the Registration of Deeds Act, all that one has to do is to satisfy the conditions of registration. It must be something done on 8.5 by 14-inch bond paper. It must meet certain formalities. But what is described in that deed as it is registered is not a certification of the thing itself. So if you do a deed between party A and party B in respect of land, it treats with the transaction between those two parties, but it does not constitute any form of guarantee as to the substance of the transaction. And under the Registration of Deeds Act, a system of title searching has developed in the conveyancing practice where attorneys at law work with a specific formula which is called moving from a root of title. They take a transaction between A and B. A wishes to sell. They historically go back into the transactional records of Trinidad and Tobago until they find something called a root of title. A root of title is ranked in order of priority as to what is the best route and what is the least route. And then you move forward from that route, checking the transaction for that particular piece of land between party A, party B, party C, party D. If somebody died, if the probate was done properly, etc. And that is how the Registration of Deeds formula treats with the thing which is passing between Mr. A and Mr. B when they are transferring land. In 1892, when we came forward with the Real Property Ordinance, Trinidad and Tobago borrowed from the Australian model, which was referred to as the Torrens system, named after Sir Robert Torrens. And in 1892, a system of voluntary registration came about, which said lands are going to be registered under a new system. This new system will involve something called a certificate of title, which is a grant from the state that says this is the certificate to the piece of land that you own. Every transaction which related to that certificate of title was endorsed on the back of the certificate of title in something referred to as memorials. So if there was a transfer, it was a memorial of transfer. If there was a mortgage, there was a memorial of mortgage. And you would refer to where in the books and records you could find the mortgage or the conveyance or the inheritance. And one certificate of title is kept at the registry, and another certificate of title, referred to as the duplicate certificate of title, is kept with the person that owns the land, whether equitably or legally, meaning a bank who has a mortgage may have the certificate of title lodged there. So this system, the Robert Torrens system, came to Trinidad and Tobago in 1892, and it was also introduced into Jamaica. Because this system was a voluntary system of registration, we found out statistically that Trinidad and Tobago, in fact, saw if you took all of its land mass, only about 15% of the land mass was locked into the voluntary Real Property Act system, because it was really only people that had a title that was difficult under the Registration of Deeds formula that came to the state and said, I want to fix my title, I want to quiet my title by bringing the lands under the provisions of the Real Property Act by an application through court, and then the state would give you a certificate of title, and that certificate of title would clean up the entire transactional history, and you therefore have a good title. There's no such thing as bad title to land. There may be defects in title, and you can fix it through various mechanisms. This being the system, we ended up with two concurrent systems. 15% of landmass under the Real Property Ordinance system, and the rest of it, 85% of our landmass, under the Registration of Deeds system. Trinidad and Tobago recognized some time ago that this was an inadequate system. And in recognizing that, in fact, the land reformation process began as far back as 1977. In 1977, reform started, and it was in recognition that the United Kingdom system of registration, which we were working on in 19th century system, was in fact radically transformed in 1925 in the United Kingdom. In 1977, we went about work, we looked to formulate, and in 1981, under the hand of Professor Wiley, a very interesting package of 7 pieces of law were brought into effect in Trinidad and Tobago. They are the Land Regularization Act, the Landlord and Conveyancing Act, the Landlord and Tenant Act, the Condominium Act, the Limitation Act, the Trustee Act, and the Succession Act. This 1981 Professor Wiley package was something which was always on the edge. In fact, while I was at law school, we had to buy the little blue book by Wiley because the laws were soon coming, but never came. In fact, the laws, while standing on the books of Trinidad and Tobago, have never been proclaimed. And they were not proclaimed because there was then the indication that Trinidad and Tobago was not in fact ready. It was going to constitute too radical a transformation of the laws of Trinidad and Tobago to have these laws put into effect, because the mapping of land, the management of land, the certification of title was going to be too difficult, and the Law Association in particular resisted the implementation of the land package. In the period 1996 to 2005, there was the Agricultural Sector Reform Program. And it was in that particular period that we saw the birth of this particular law as it now stands. In fact, in 1998, God rest his soul, Mr. Justice Gaya Prasad, who has just passed away and who really gave a great deal of his life to Trinidad and Tobago, he sat as the chairman of the Law Reform Commission, and under the stewardship of Attorney General Ramesh Lawrence Maharaj, he and the Law Reform Commission was tasked with a package of laws, and that package of laws, which this bill seeks to amend now, involved the promulgation and creation of the Registration of Title to Lands Act, which we now seek to amend, as well as the Land Adjudication Act, the Land Tribunal Act, and the State Suits Act, which we will come to treat with in other debates in the Senate. These laws were also not proclaimed, and they were not proclaimed largely again because of the state of readiness of the legal profession, the bankers, the willingness to buy into the situation, and very importantly, because the regulations were not dealt with at the time of the dealing of the legislation. Enter now the 2003 committee established to review the package. That committee went to work under a P&M administration to review the particular package, to finalize amendments, and those amendments were in fact completed on the review completion on April 4th, 2005. In the year prior, in 2004 to 2005, there was a lot of consultation on it, but very importantly, in the year 2008, an implementation strategy for this land was earmarked and launched, and the government went to work to ensure the creation of the regulations, and very importantly, for the adoption of the manner in which we would demarcate land, survey land, register land, and an excellent project under the IADB, the Inter-American Development Bank, was set into motion, and that project involves the request for grant of $100 million US for Trinidad and Tobago and $7 million US for Tobago to treat with the registration and implementation of these laws. In the last 10 years, this system of development with the IADB continued. The loan has been perfected, it stands ready. The Ministry of Agriculture, and I'm sure the Honorable Minister will speak to this, went into the GIS mapping and the cadastral mapping of the land of Trinidad and Tobago. And I think it's safe to say that Trinidad and Tobago is now in the position where it can implement the benefit of the law by the utilization of technology, in particular the Geographic Information System and the Cadastral Information Management System. But this runs alongside a state of readiness which I've had the pleasure as Attorney General to push at high level and full gear, which is the manner in which the land registry of Trinidad and Tobago is improving itself and is moving to an entirely electronic platform. And I'll come to that in great detail a little bit later. Comfortable that not only does the system make sense in law, but it can be operationalized, because we've taken care as a government in treating with the law to make sure that we operationalize the laws at the same time. So, Madam President, we come to this Registration of Title Lands Act, and it was important to demonstrate the historical journey to getting here, as we now stand many years later, 173 years later from our original systems. We now stand 18 years later from the actual law's passage, and it reminds me of the echoes of our recent debate on the DNA legislation when we come to the point about when is the line to be drawn. The government proposes the amendments to this particular law as a long-term solution, because we have a very important short-term and medium-term solution which will join this Parliament's agenda very shortly. We recognize that implementing this system, rolling out the process, will take a moving mechanism across Trinidad and Tobago over several years until all title is brought under the Registration to Title Lands Act. That will take a few years. And in the meanwhile, we recognize that there is a neat fit to treating with the system of abuse of our land, the system of corruption and fraud that has infiltrated the process, by certain short-term remedies which we will be bringing to Parliament, hopefully within the next couple of weeks. It has already had consultation. So this is long-term, and whilst the grass is growing, we have another pasture to feed the horse, and that's the short-term and medium-term agenda as we seek to bring amendments to the Registration of Deeds Act, the Conveyancing and Law and Property Act, the Real Property Act itself. We seek amendments in a separate package which will come next. So let's look now to this particular journey in the 10th Parliament, and now as we stand in the 11th Parliament. I know my colleagues opposite are very interested in this, and in fact, it was under the hand of the then Minister of Legal Affairs, the Honourable Member for St. Augustine, as he is now Prakash Ramada, that we saw the introduction in 2011 and 2012 of a bill which is similar in terms to this one. Both of those bills regrettably lapsed. One lapsed on the 17th of June 2011, and the second bill, which was in similar terms to the first, lapsed on the 10th of July 2013. This particular Registration of Title to Lands Parent Act is sought to be amended today by 23 clauses. The 23 clauses before us treat with some minor issues and some major issues. In treating with the minor issues, I will go through those, and in treating with the major issues, I'll explain those, because there are a few of them that are quite novel and that require some deeper explanation. So, Madam Speaker, Madam President, forgive me, as we proceed into the bill, I ask honourable members to read the amendments proposed in this bill in light of the formula of the Parent Act. The first clause, of course, is just a simple one. Forgive me, permit me to put on record, the objectives of this bill are to treat with the quieting of title, meaning where there are disputes in relation to land ownership, boundaries, etc. This bill is intended to quiet title and put certainty for the benefit of Trinidad and Tobago. Permit me to put on the record that Tobago is the area that the government intends to start this law in, because Tobago is the area that has the greatest title being unquiet. Their title system is in a mess, quite simply, and for years it has not been dealt with. After Hurricane Flora passed through Tobago in the 1960s, almost every person living in Tobago says that their titles were lost, because people stored their titles in a church, in a trusted area. And Tobago, coming from a plantation-type environment, and then the lotification and positioning, going down through families, etc., as the estates began to dwindle and the land allocation went out, Tobago finds itself in a very interesting scenario, where people have lived on the land for generations and cannot go to the bank to mortgage it. They can't go to the bank because they don't have title to the land. And the method by which they can secure their title is easiest done under the Real Property Act. They would have to apply to the court to bring the lands under the provisions of the Real Property Act. They would have to go to court, file affidavits, do title searches, have the Commissioner of State Lands come, speak to the land titling of Trinidad and Tobago, deal with that process, have a judge determine the evidence, have witnesses speak to how long you've been on the land, how you developed, show a degree of connection to the land, which is exclusive to connection that somebody else may have, because there may be a competing prior title. You have to treat with the state lands limitation periods, whether it's 30 years for state lands or 16 years for private lands. And after you go through that process in court, one thing is for certain: you would have spent a lot of money and spent a lot of judicial time. And the Real Property Act itself finds itself an inappropriate remedy to this situation because it just costs too much and takes too long. And the people of Tobago have been crying out for this particular point, and in particular the THA. And this particular bill before us is intended to bring to life the laws which have sat on the books of Trinidad and Tobago for 18 years, start with Tobago, register land in Tobago, and then allow Tobago to be bankable, allow Tobago to have land inherited, allow Tobago to settle its title and quiet its title. And that's a very important campaign promise that we made, and it's a commitment which is very deep in the hearts of all of us, I am sure, as honorable senators stand. So back to the bill. In the 23 clauses, as we look to clause 1 of the bill, it's really quite simple. It's intended, the bill as a whole, to treat with the objectives, to clarify and secure land tenure, to identify state land, to establish a modern land adjudication and registration system, to have all land in Trinidad and Tobago registered under one system, to establish a new register which will record and guarantee title and allow for simple and secure dealings, to establish a land tribunal, as we'll come to in another bill. So those are the effective main policy objectives. The bill itself, Clause 1 and Clause 2 are the standard positions. Clause 1 is the titling. Clause 2 is the interpretation of certain sections. When we get to Clause 3, we're looking to the amendment to Section 2 of the Parent Act. And in Section 2, which is Clause 3 amends Section 3 of the Act. In Section 3 of the Act, we are introducing into here the phenomenon of a land adjudication officer. We're tying it to the registration, interpretation provisions which appear in the Land Adjudication Act, which we'll debate at another time in the Senate. We're removing the reference to a certificate of title, and we're instead calling it a land certificate. Why? Because certificate of title is the terminology used under the Real Property Act, and it could cause confusion because Clause 22 of the bill, specifically in introducing a new Section 85 of the Act as we propose, really abolishes, as we bring lands under this Registration of Title to Lands Act, we are abandoning on a piecemeal basis the Real Property Ordinance which would have prevailed previously. We treat with the definition of a condominium. I ask you to note that we still have the Condominium Act 1981. We're working on amendments to the Condominium Act. Members will recall that we treated with the Valuation of Land Act, and we dealt with the Property Tax Act, and we also identified the feature of a condominium as an important landmark on Trinidad and Tobago's property management structures, and therefore we have treated with a condominium by way of specific definition. We've treated with the removal of the definition of court. In the Act, it says court is court of appeal. We are now removing it to say that the court is not defined as the court of appeal, to allow for the magistracy, the High Court, and the Court of Appeal to be preserved by way of access. We are treating with an encumbrance being a proprietary right held by one person over land, because we've defined land in a very specific way. Again, it allows for parity between the Valuation of Lands Act, the Property Tax Act, the Registration of Title to Lands Act, as this one is, and we have left it as land because property, of course, is a wider concept. Property may be intangible, it may be tangible, it may involve intellectual aspects as opposed to real aspects. We treat with maintaining the concept but clarifying as to how this bill, how this act is going to really be giving indefeasible title. Real Property Ordinance, Real Property Act, RPO as we call it, gave you a certificate of title, and that was almost viewed to be bulletproof, indefeasible. Of course, you are not indefeasible in the light of fraud or certain types of misrepresentation or certain types of gross errors which can vitiate the concept of indefeasibility. But this act allows for a closer version, as you will see in sections 34 and section 35 of the Act, the Parent Act. You will see the management of an indefeasible title. And we give the certain exceptions. I stick a pin here. The manner in which trusts are treated in Trinidad and Tobago is the subject of proposed significant amendment by this government. The breach of the principle of trusts, the priority of the equity lying over the law, is something which has allowed for an abuse in this country, and honorable members will see legislation to be introduced into the Parliament very shortly to treat with that. So whilst this bill gives recognition to indefeasible title as it is contained in the Act, we propose to recognize that there's a caveat for trusts, but we're going to treat with that in a separate round of amendments. So I'm just bearing in mind that this indefeasibility of title and the abuse of trusts is going to be treated with in a separate fashion. Yes, please.
President, I want to thank the AG for giving way. While you have not too much time, I don't want to take too much time in asking this question. What you are aimed at by this legislation is getting to one system of registration of title. And we have two systems now, registered and unregistered, under a different system. As part of your contribution, would you just simply spend a few minutes on just saying, you said it's going to be done piecemeal. We'll end up at the point where we would have a total registration at one point in time. Would you just explain in a few minutes of your time, if you can, how you propose that the government treat with it in a piecemeal basis to bring the two systems to coalesce together in one system at the end?
Sure.
Thank you.
Thank you. That's a very important observation, Senator Rambin. I welcome you back. We missed you for the several weeks that you were out. It's good to have you back. So the long-term system is this Registration of Titles Act. In this long-term system, we intend for all land in Trinidad and Tobago, through the land adjudication process, through the land tribunal process, to eventually be registered under this act. But bearing in mind that this is going to take some time to get there, as we survey land, as we bring people forward to make their representations as to titling, etc. In the meanwhile, we propose to utilize the Real Property Act and the Registration of Deeds Act and the Conveyancing of Law and Property Act as they exist, and then begin to transition them into this. But importantly, recognizing that there are weaknesses in those laws, Registration of Deeds Act, Conveyancing and Law and Property Act, and the Real Property Act, we will be coming to Parliament in a matter of weeks to treat with amendments to those laws to manage the mischiefs which we have spotted in those laws whilst we channel and funnel into this new registration of titles system. Madam President, Madam President, again, may I ask what time I'm due to officially end? Full time?
You finish at 29 minutes past 11.
Thank you, Madam President. Madam President, we're treating with the introduction of a definition for provisional title. Provisional title is critical to a very large section of Trinidad and Tobago. Some people call them informal settlers, some people call them squatters. Provisional title is something that is to the heart of people who have lived on lands that they don't own in law and may have done so in circumstances where they can be the beneficiary of the land if the system is made simpler and cheaper. Under the Real Property Act, squatters have to find money to make the application to come under. Under this system of registration, it's the state taking the obligation on a rolling measure to get to the land and do the survey, do the demarcation, do the registration through a process. This affects 250,000 squatters in this country. And that's no small number, Madam President. And this is something which people who are living in less than adequate conditions are surely dying to have addressed. because there can be no greater dignity to someone than the privilege of owning land or knowing the certainty of land. After all, state services are accessed by way of land ownership at times, or possession, which is dealt with. So this provisional titling is a critical feature. We've added in the senior assistant registrar because we have taken note of the fact that these positions of assistant registrar, senior assistant registrar, are current features of the operation of the registry and exist under the registration of deed system, etc. And to allow for that transition, we're making sure that the Registration to Title of Lands Act matches up with the existing structures at the Registrar General's office. Madam President, we're next moving to Clause 4 of the bill. Clause 4, Clause 5, Clause 6, Clause 7, Clause 8 are all interrelated. And they seek to amend, respectively, Sections 5, Section 6, Section 7, Section 9, and Section 10 of the Parent Act. And that is the introduction of Senior Assistant Registrar throughout these provisions to take care of the existing structure. Sometimes people ask, well, why are you legislating structures? And I'll tell you why. It's because the CPO's office, the Public Admin Administration in the Ministry of Public and the PMCD, they often have a difficulty in finding terms and conditions which match up to salaries because they're not defined in law. And that's why we've taken the approach in the judicial structures and in these structures to legislate positions so that we avoid the back and forth between salaries, terms and conditions, and job descriptions, which would otherwise cause you to have nobody working in the position. So we're legislating it here. We then move, Madam President, to Part 3 of the Parent Act, where we treat with Clause 9 of the bill. Clause 9 seeks some degree of similarity between Clause 13 of the bill. And in Clause 9 of the bill, we are introducing a fourth element into the folios. And let me explain what Section 13 of the Act does. Section 13 of the Act is really a core provision. It describes what is referred to as the folio system. A folio is that indefeasible originating document which gives you your title. And there were 3 folios existing in the Act. Folio for every parcel of land adjudicated under the Adjudication Act. A lease folio, because remember there's freehold and leasehold land. You may own land by having a lease for 99 years or 199 years or the whole of Woodbrook for 25 years or 30 years. That's the second type. Then you have an interest folio. An interest folio takes care of documents like mortgages, like other transactions, etc. But we didn't have a condominium folio. And in the high-rise or lateral multi-home development, it was necessary to introduce the condominium folio so that we could aggregate that. Because remember, the government's intention is to come back with the Condominium Act 1981, do surgery to that act to make it relevant. Because many condominiums exist where the management companies don't operate, where the owners can't be found who own the freehold reversion. People can't transact their business by having title because their shares are in disarray. They find themselves with hundreds of thousands of liability in dollars for annual returns at the company's registry, which was not done. So the condominium structure is another type of landlessness when they have been left to management that does not work. And therefore, another screaming element, apart from Tobago, apart from squatters, is the condominium structure in Trinidad and Tobago. And we just have to fix that. And it's been too long in the making. 1981 is when that law came about. Madam President, the next position that we seek to amend is Section 14 of the Act. In Clause 10, we treat with an amendment there. And what we're doing here is making sure that we have the adjudication record and folio made clear so that there's no ambiguity. But very importantly, by the introduction of a new subclause 2, we're describing when the first registration happens. And we've clarified it to say, first registration of any parcel shall be effected by the preparation of a folio in accordance with Section 13 and the signing by the registrar of the particulars of ownership and the particulars of encumbrances, if any, appearing. So we are making sure that there are anti-fraud mechanisms so that it isn't just any registration which went in. it must be registration and documentation of the particulars under the hand of the officiant, who is the Registrar General, who perfects that process. So the verification process is applied before registration is effected. Madam President, we next go to Section 19 of the Act, which Clause 11 seeks to amend. And in that, we have removed the words folio or in subsection 2, because we wanted to make sure that there was no confusion between the folio and interest folio. And there was a duplication in language there, and we had to just tidy that up, and that's what that amendment is about. Madam President, Clause 12 of the bill treats with Section 24 of the Act. Again, this is the change in naming. We're no longer using certificate of title. We're going to land certificate to avoid the confusion with the Real Property Act. We then, of course, move to Section 29 of the Act, and this is an important one. Section 29 of the Act, Clause 13 of the bill proposes to amend Section 29 of the Act, and Section 29 of the Act treats with an instrument or document evidencing a dealing has legal effect and passes estate or interest in land when a memorial is endorsed on the folio. Again, this is an anti-fraud mechanism to ensure that there's supervision so that functionaries under the Registrar General can't get it wrong. Clause 14 treats with a very important aspect, and that is to treat with an amendment to Section 30 of the Act. Section 30 of the Act, as it was originally drafted, was inadequate. It only allowed the Registrar General to effect rectification or amendments if there were major defects. The language said, where any instrument that has been lodged and registered in accordance with the provisions of the Act is subsequently found to contain material defects, and then certain things went on. We have broadened the categories in a new Section 31 to allow for the Registrar General to act in relation to any instrument presented for registration in the following cases: in formal matters and in the case of errors or omissions not materially affecting the interests of any proprietor. It's similar to what we call in court the slip rule. B, in the case of at any time with the consent of all persons, so there's a voluntary transaction between the relative parties, where in the third case, upon resurvey an area shown to be incorrect, in such case the registrar shall first give notice to all persons appearing, again to allow for self-generating solutions, and then importantly, upon the receipt of any order of the court, so that the registrar can perfect the order of the court without the delay of transactions in between. We then go, Madam President, to Clause 15 of the bill, and this is an extremely important clause. Clause 15 of the bill treats with an amendment to Section 34 of the Act. Now, Section 34 treats with the conclusiveness of the register, It said, subject to subsection 2, the title of every proprietor of land subject to this Act is, except in cases of fraud, absolute and indefeasible, and accordingly shall not be impeached or affected by any of the existence in other persons of an estate or interest, whether derived by grant from the state or otherwise. Subsection 2 said the proprietor of any estate and land subject to this Act, whole same subject to, and then it traverses items A through to O inclusive. But Section 35 was not made specifically subject to Section 34.2. So Section 34 of the Act said...
Attorney General, you have 5 more minutes.
Oh my. So Section 34 of the Act said your title is indefeasible. Section 35 of the Act said that it was not subject to Section 34.2. As we transition to the perfect title, it was important to make sure that we made it subject to Section 34.2 because as we moved to clean title and quiet title, you had to make sure that the items which were caveated out still form part. So there's still an obligation to search. There's still an obligation to search title so that you carry out due diligence through an attorney at law. Let me jump to a very important clause, Madam President. That is the search parameters. The searching of title is proposed to be amended here in a new section by Clause 20 to an amendment to Section 73 of the Act. We propose in this system that There is a difference between an official search for somebody who's about to buy property or mortgage property and the public search. When you have an official search, the transaction results in a standstill. You can still receive documents affecting the title, but they're not registered while the search is going on with the consent of the parties to the transaction, i.e. the owner of the land and the bank or the person who's buying. We say in that official search parameter, only an attorney at law or his clerk can have the official search. But we make sure to say members of the public can use the electronic system, they can order certified copies, etc. So we put the public aside to keep the transparency, but in the official search, it's to make sure that we don't have a practical situation of fraud crawling into these transactions where documents can find themselves part of the title in fraudulent ways. And in putting this parameter to attorneys at law, I should say, we will be introducing very shortly a unified PIN number for attorneys at law. And transactions are going to be linked such that your birth certificate PIN number, your marriage certificate PIN number, your change of name, your practicing barcode, all of those are dealt with in one transaction so we know who the players are. Whilst we also introduce amendments to the real estate profession, which has been unregulated to date and which is coming upon us shortly. The suspension period, once lifted, after the 14-day suspension is done, all things received in the buffer zone go in the order of priority that they came in by time, by date, etc., and the title continues. So we are not disaggregating, we're not removing the public in any way, we're protecting the transaction from abuse of fraud and errors and omissions that can happen there. Madam President, the last clause to reflect upon really is clause 22, where we put the transitional provisions as to how we propose to move the system from the Registration of Deeds and Real Property Act system into the Registration of Title system. Madam President, in the merger of portfolio of the Attorney General and Minister of Legal Affairs, I want to say this. I think I'm the first Attorney General with significant conveyancing and mortgaging and transactional and corporate experience. And for me, the land registry has been the golden pot. It is the golden pot to evidence where fraud is, where wealth is, where corruption is, where benefit can be, where families have their entire lives at stake. And that pot is the pot which will feed the anti-corruption package. And it has been a very significant point of focus for me. It is an integral part of the system. We have many operational procedures which I have not been able, because of the constraints of time, to address. My learned colleagues will assist me in that. I will address, certainly in the course of the wrap-up, the very important operational aspects, be they electronic, be they the land registry, the other systems to come. But I dare say it's been enough time. 173 years of system needs to evolve. 18 years of analysis paralysis needs to end. This position of giving people the benefit to their lands, of allowing squatters the privilege to access things which they are entitled to access, or acquire their title, Tobagonians to be satisfied, general interest of mortgagers and wealth management in this country, it now takes a quantum leap today by perfecting the process. I beg to move.
Honourable Senators, I shall now propose the question for debate. The question is that the bill entitled An Act to Amend the Registration of Titles to Land Act 2000 be now read a second time. Senator Mark.
Thank you, Madam President. Madam President, how I intend to approach the intervention on our bench as I begin would be to look at the absence of public consultation and people's participation. I also want to look at the importance of the registration of titles to land and their benefits to national development, economic growth, social equity. I also would like to look at the whole issue of the linkage, which I found very strangely absent from the Attorney General's intervention, there's a linkage, and I hope my colleague from the Ministry of Agriculture will see linkage between land administration and management and the global agenda for 2030 and the attainment of the 17 sustainable goals. Particularly, you have 5 of them that are land or land-related, Madam President. I think that is a very important aspect of our discussion when we deal with land administration and management. I also want to look at the modular versus the integrated approach. That is another area. Then, Madam President, what would also be critical in examining this whole question of land governance and land administration has to do with what I would like to describe as the challenges that we face in doing business, the registering of properties, as an example, how long it takes and why it takes so long. Madam President, I think it's important to look at secrecy. I don't support the view expressed by the Attorney General in terms of an amendment to Section 73, leaving out ordinary people to access the Registrar General's office. I believe in sunshine rather than darkness. And then, Madam President, one of the areas that I consider to be critical is for us to look at modernizing land administration using modern technology. Madam President, to come and tell this country and this parliament that you're going to plug fraud and corruption, right, by going down the old road that we have here is not going to achieve it. I would want to bring to the attention of my honorable colleague, who is aware that in many countries, including India and Denmark and New Zealand, they use drones. In other words, modern technology, mapping, surveying, Madam President, in a very serious way. And then I also want to indicate that we have a couple of amendments that we would want to advance to strengthen the legislative framework. Madam President, you would appreciate that if we are to advance in this particular area of land administration, it is so important that we seek to appreciate under the registration of titles to land amendment bill, which is linked to the parent legislation. We need to fully appreciate that one of the central pillars of any modern system of land law is the registration of title to land. And Madam President, land registration describes systems by which matters concerning ownership, possession, or other rights in land can be recorded to provide evidence of title to facilitate transactions. Madam President, there are, to me, a number of significant benefits that we can derive from the approach that we are seeking to advance in this piece of amendment based on the parent legislation. When you, as my colleague Senator Ramdeen said, what the government is seeking to do is to deal with 2 areas of registration of titles and bring, at the end of the process, one particular outcome. So instead of going with the common law and deed registration, what the government and what the law is attempting to do, Madam President, is to go to what is called formally certificates of title that has now been deleted, and we are going now to land certificates. So that is the objective of the exercise that we have embarked upon here through these amendments. So the title register constitutes the evidence of title and replaces proof of ownership by historic deeds and documents. And therefore, if your land is registered, future dealings relating to it are quicker and more efficient because you have eliminated the requirement that is sometimes often substantial, bundles of pre-registration deeds and documents to be considered. So that is one of the advantages that you can see immediately, Madam President, with a united or unified approach to land certification rather than land registration from the perspective of the deeds. Then we go on now, Madam President, to a conclusive, once you talk about registration of titles, it is a conclusive registration process, and it tells you about the ownership of the land, and it provides a state-backed guarantee to titles of land, Madam President. The Attorney General raised something about absolute title and provisional titles. We will talk about that a little later on, Madam President. But, Madam President, what this does, it provides greater protection against a claim for what is called adverse possession of land by unauthorized occupier. And this is due to the different requirements for a successful claim in relation to registered land compared to unregistered land. And, Madam President, when we deal with the registration of titles and you get what is called a land certificate, it provides a clearer picture, Madam President, of the legal state of the land by setting out the rights and covenants which benefit or burden the title in question. Madam President, I want to let you know that when we deal with the matter of registration and security of tenure, because at the end of the day, what we are seeking to do from our perspective, and that was the vision and the philosophy of the framers of the legislation in 2000, was to move towards a home-owning democracy where every citizen, regardless of his race, creed, religion, or station, will be entitled to a piece of property, a house that he can call home. That is what the objective is. And, Madam President, when I did some research on this matter, I was shocked to learn that the only country in the world where you have 90% home ownership is a country called Mauritius. 90% almost of home ownership exists in a country called Mauritius. And the average in the world is 74%. But in Mauritius is 90%. Madam President, the registration of title to land will enable security of tenure for all and effective management of land use and natural resources, which in turn will facilitate economic growth of a nation, social equity and justice, and environmental sustainability. These are all critical ingredients if we are talking about revolutionizing land administration and land management. Madam President, sound land governance is essential to achieving the 2030 global agenda manifested in that very important summit which took place in at the United Nations in 2015. Madam President, land governance is about policies according to the United Nations, processes, and institutions by which land, property, and natural resources are managed. Land administration, and that is what we are about today, It's about the registration of titles to land, and that involves land administration, land management, Madam President. It includes land tenure. It includes land use. It includes land value, and of course, land development. Madam President, there are, from my research, some 6 goals that are related directly to this land management and administration package that we are going to be dealing with over the next couple of days. 6 SDGs goals. Goal number 1, Madam President, is ending poverty in all its forms everywhere. And there's a target number 4, which deals with providing all men and women with equal rights to ownership and control over land and other forms of property. So they give a goal and there's a target in order to satisfy that goal. Madam President, goal number 2 talks about ending hunger, and that is related to target number 5, which deals with a land component. Then there's goal number 5 that deals with gender equity, Madam President. Then there's goal number 11 that deals with sustainable cities. Goal number 15, dealing with life on land. And goal number 16, which deals with peace, justice, and very strong institutions. So, Madam President, for these goals to be achieved, we need good land administration. We need good land governance and management, Madam President, on a country-wide basis. So we need to appreciate that what we are dealing with, Madam President, is not just simply addressing land administration from the perspective of ensuring that titles are given or land certificates are issued. It is much more than that. It is about economic growth. It is about economic development. It is about sustainable development within the environment. It is about social equity and justice for all. So we have to see the broader picture when we are debating and discussing this matter of land management in our country, Madam President. Madam President, I would like to suggest, and based on the research again, there are some 18 institutions, according to the IADB, that are involved, Madam President, in land management and land administration in Trinidad and Tobago. And if we are to deal, Madam President, with this question properly, you have to have, as I said, not a modular approach, but a more integrated approach to land management, Madam President. And so, Madam President, as I said, if you go to the literature, you will see, for instance, the state of play in Trinidad and Tobago. The Attorney General did indicate to us.
Madam President, I'm sorry to interrupt a learned friend in a long day. 46-1, please.
Yes. Senator Mark, I am giving you a lot of leeway. You will continue. I may have to make an intervention at some time because I really need you also to move into the general issues about the bill itself, okay?
Yeah. But, Madam President, I'm sorry that the Attorney General, my contribution is above his head. No. Well, above him. I'm sorry. But I thought because,
Madam President.
I withdraw. I'm sorry that the Attorney General is not fully appreciating the linkages that I'm making towards this subject matter and the importance of development and growth in our nation. I thought that was simple logic. I was trying, Madam President, to establish.
Senator Mark, the Attorney General invoked a standing order, I have allowed you to continue. So move on, please, okay? And don't engage the Attorney General on what he did before, okay?
So, Madam President, what if the Attorney General, well, through you, would want us to just stick to the bill and not deal with the matter in a holistic way, Madam President, I want to draw to your attention some of the realities that the IDB outlined in its report called a methodological framework for comparative land governance research in Latin America and the Caribbean. And on page 22, we are talking about land registration. And Madam President, if you are going to engage in a more efficient registration of land so that people can gain title and have proper ownership, it helps in economic development of any nation. It promotes competitivity. Madam President, according to the World Bank, in 2014, it took 77 days, and it cost 7% of the value of the property to have a commercial land transaction registered in Trinidad and Tobago. No, this is a nightmare. And we are trying to ease up the way that we do business in Trinidad and Tobago. Madam President, as we speak today, we are talking about land titles. The Attorney General said that only 15% of the population of this country is in possession of genuine titles to land, meaning their certificates of title, before we change it after this amendment to land certificate, only 15%. So they are about 85% of the population. What the Attorney General did not tell us is that out of that 85%, Madam President, only 35% may be in possession of proper registration deeds. So there are almost 50% of the population in this country, according to the IDB, that may not be in possession of title, either a registration deed or some document relevant to ownership of their property. And that is why this effort is being made. Madam President, we are told by the IADB that 1/6 of the population, which is about over 235,000 people or thereabouts, live in an informal way in this country, what you call squatting in this land. And we have to find ways and means of issuing these people with some degree of settlement in terms of comfort. We know that in 1998, there was an act called an act to regularize persons in Trinidad and Tobago who were squatting, and there were processes involved in issuing those certificates to these people and to bring about some degree of comfort. Madam President, you would recall it was first a letter of comfort, then we went on to a statutory release, then we went on to what is called a deed. So you have close to about 230,000 people in Trinidad and Tobago who are not being given what I call proper title, Madam President. Madam President, so when you talk about tenure of security, 50% of private and family land is formally recorded. The next 50% is not properly recorded. What I found to be quite interesting, Madam President, is that in terms of women, only 14%, according to the IDB, were landowners in the Republic of Trinidad and Tobago. That was a very interesting statistic, Madam
Senator
President.
Mark, I am listening. Senator Mark, I'm listening very attentively to what you're saying. I want to remind members about Standing Order 65, which deals with the remit of this second reading, which is what we're involved with now. Senator Mark, I need you to try and deal a little more with the bill at hand and not a general issue about land in question, okay?
Madam President, seeing that you would like me to deal with those matters, let me comply. Madam President, the Attorney General raised a matter of provisional title to land. And I wanted to ask the Attorney General, when we talk about provisional title, I looked at the legislation, both the parent and the amendment, and there was the whole concept of what is called provisional title, but when it came to the definition of provisional title, it was in the definition section. And it sent me now to what is called the Adjudication Act, Madam President. Do you have a copy of the Adjudication? 49.1, Madam President. Madam President, I'm referring to this act, that provisional title, which is before us, Madam President, means a title to land declared to be provisional under Section 16 of the Land Adjudication Act. That is what I'm dealing with here. I'm saying that this is what is before us. And I'm making reference to it. You made, when I say you, the Attorney General made reference to Land Tribunal.
Senator Mark.
It was before us.
Yes, you notice that I have allowed you. You could have a seat, Senator Mark. You can deal with how you're dealing with it, but the Attorney General is merely pointing out not to go too much into that amendment bill. So, Madam President, we will come to the land adjudication matter, as you said, when we're dealing properly with it. But when we deal with provisional title, what I was trying to get is the meaning. And what I got from the definition that is before us is that when you talk about provisional title, you're talking about somebody in possession of land. A possession. You could be in possession of the land, and once you become, you get in possession of the land, you can, within a period of time, with the appropriate steps being taken, become ultimate owner of the land. And there's where, Madam President, I thought that that is an area that we need to have some clarification on. And I'm sorry that the Honorable Minister is not here, the Minister of Agriculture, because, Madam President, we saw recently in the newspaper where even within the Ministry of Agriculture, Madam President, where you had land fraud being perpetuated, and the minister had to take action to deal with land fraud. And he wrote the Prime Minister and to get action in... Don't refer to... You dealt with a situation, just move on in your contribution, please.
No, but I'm saying if I'm dealing with land, and one of the questions with land administration, Madam President, you must always remember that we are dealing with also with the Parent Act. This is the basis of this amendment. So in the Parent Act, it talks about, for instance, fraud in the Parent Act. And I'm just drawing to your attention, in the Parent Act, when we talk about fraud, we have a situation where, Madam President, I would have liked to have clarification on lands that are being occupied, some 15 acres of land being occupied at a place called Monjalu Farm for the last 5 years. I would like to have some clarification.
Point of order, 46.1.
Senator Mark, please, I have to ask you to really deal with the bill at hand, okay? You're talking about some issue, the issue of fraud that can arise, but you've made your point and you can now move on to another point, please.
Madam President, let me remind this Honorable House that in the Parent Act, and I want to remind Madam President, your good self, when I looked at this bill that is before us, I saw where the first thing that jumped out at me was this, Clause 2. In this act, the act means the Registration of Titles to Land Act 2000. So, Madam President, there is a link between this amendment and the Act of 2000. I cannot debate this matter without making reference to this act.
Senator Mark, you know, no one is preventing you from making reference to the Parent Act. And no one is preventing you from speaking. But please, Senator Mark, be relevant. Okay?
Well, again,
Senator Mark,
okay.
Yes.
I don't want to argue with you, ma'am.
Yes.
You know, we are friends. No, please. So, Madam, I'm making the point that there are some issues when we talk about land. This is about the registration of titles to land. And we know what the definition of land is. And if, Madam President, we are talking about land, and we are saying that there is, in fact, some illegal occupation of land in certain parts of this nation, I want to get clarification as to whether these people who are occupying these lands have been given the necessary permission. Because land, Madam President, not only includes private land, it includes state land as well. It is both state land and private land. And if there is, in fact, Madam President, such a situation taking place, I would like some clarification. And I call on the Attorney General to tell us whether he's aware of scores of acres of land at Mount Jalu being occupied by an individual by the name of Ricky Ramcharan. I would like the Attorney General to tell this House if that gentleman has been given permission by the Commissioner of State Lands to occupy this land that is at Mount Jalu Estate, or whether this gentleman...
Senator Mark, you have just embarked on a course that I have asked you not to do. And you have even taken it further. We are dealing with the Registration of Titles to Land Act. Later on in this debate, and am I going to hear, because trees grow on land, we could talk about the different types of trees? We need to be specific and relevant to the bill that is before us. Senator Mark.
Madam President, by the time I finish, I'm in trouble. I'm in trouble. Among the, I'll have to sit down just now. Among the time I've been seated, ma'am. Anyway, Madam President, may I continue again? I thought this is a bill that would have attracted our support, and we are trying to strengthen it. But it seems like we now have to be in opposition to this bill. Madam President, may I continue? Madam President, may I ask the Attorney General through you, when we talk about, I'm referring, Madam President, with your guidance, to Section 4, 5, 6, 7, 8, and 9 of the bill. Although I'm not supposed to be doing that unless I'm in committee stage, but I'll deal with it in any event. Madam President, when we talk about a senior assistant registrar, we saw where, when we talk about the registrar, there was a specific qualification for the registrar in the Parent Act. The person had to have, I think, a minimum of at least 7 years of experience. That is in the Parent Act. But in this amendment, we have added the word, we have removed assistant. No, we have added the word senior to assistant registrar. What is missing, Madam President, is the qualifications for this particular job. Is the Attorney General saying through you, Madam President, that somebody can graduate from Sir Hugh Wooden Law School tomorrow and land a job as a senior assistant registrar? Because there is no qualifications.
There is in Section 6. Come on. Read the Parent Act.
Attorney General.
Madam President, I have asked the Attorney General through you to provide us with a specific qualification for this. I haven't seen it in Section 6, and if he says it's there, we will deal with it at committee stage. I am not seeing it, and I'm indicating that an amendment will be put by this side to address that question, Madam President. Okay? Because I'm not seeing it. Madam President, can the Attorney General indicate to us what is the link between this law and the Property Tax Act and the valuation of land tax? I would like him, in his winding up, to indicate what is the link. Because, Madam President, if you go to the legislation, you will see where reference is made to section 34 of the Act, Madam President. That is the Parent Act. I think it's 34.2. If you go to section 15, Madam President, you will see where we are talking about under section or clause 15. Section 35 of the Act is amended by deleting the word a person and substituting the word subject to 34.2. Madam President, of course, I seek your leave to refer to the Parent Act, to go to 34.2, so you can follow what I would like to advise and advance. Madam President, if you go to 34.2, you will see where the proprietor, which is the owner of the property, is subject to this particular provision, 34.1, but with the following exceptions. You will not be able to get absolute title according to section 34.1 if, one, there's any unpaid money, and that is M, which, without reference to registration under this Act, is expressly declared by any law to be charged upon the land. And two, if you go to O, any public right-of-way and any unpaid taxes, charges, rates, assessments, and duties. So, in other words, Madam President, the squatters that we are supposed to be taxing, property taxes, Madam President, what will happen to their entitlement if they are owed under this section unpaid taxes, charges, rates, assessments, and duties? Would these people be denied their right to occupy the land? This is an area that I would like the Honorable Attorney General to clarify for us, Madam President. Madam President, we take strong objection to what the Attorney General has proposed in Section 73. And Madam President, may I advise you to join me as I take you on a journey to Section 73 of the legislation, so you will understand why the Attorney General has not provided this House with a plausible explanation for the extinction of myself as a person who wants to go to the registry or to the Registrar General's office and conduct a search on property that I am suspicious of involving any member in this society. Why is the government of Trinidad and Tobago trying to deny me, Madam President, the right to enter the Registrar General's office, pay my fees, and get the requisite information? Hear what the Attorney General is telling us, Madam President. Hear what the Attorney General is telling us. In the year of the Lord,
Senator Mark, you have 5 more minutes, please.
Madam President, in 2018, the Attorney General is telling us in 2018, Madam President, that we must not have any entitlement to a certified copy of any document that is available to the Registrar General. You know what the Attorney General is telling us? We must become so computer literate. If you are not computer literate and you don't have access, Madam President, to a computer, you can't access documentation at the level of the Registrar General's office. Now, how can we live with that kind of explanation coming from the Attorney General. We reject that out of hand. And we serve notice on the Attorney General that, like Barry Sinanan, we ask the question, what does the politician has to hide? Barry Sinanan, when this matter was debated in 2000, he asked the question, are we removing any person from the legislation who can now access, Madam President, any documentation at the Registrar General's office? The Attorney General, Lawrence Maraj, got up and said, no, we are keeping it. And he said, I'm happy because I was wondering if we remove that, what will be the impact that will have on politicians? Politicians will now be able, Madam President, to hide behind that kind of arrangement. And we are not going to be party to that, Madam President. So we serve notice on the Attorney General that we intend to reinsert Section 73 to give the ordinary man and woman, including Wade Mark, Madam President, become an ordinary citizen. I must have the right to go to the registrar's office and access information as I deem fit, and I pay my fees. Don't deny me that right, Madam President. I think it's an affront to my constitutional rights, and it's an insult to the people's intelligence, the ordinary people's intelligence. And, Madam President, don't come and tell me you are trying to avoid fraud. Madam President, there is modern technology in existence today that can deal with that matter. It is the absence of proper systems in the Registrar General's office, lack of infrastructure, modern technology, interoperability between one area and another section of governmental arrangement that is responsible for what is taking place at the level of the Registrar General's office. So we do not buy that argument, Madam President, whatsoever. We think the government is hiding. We believe that they have something to hide, and therefore we are going to exactly shine the torchlight, bring the sunshine, bring the rays of the rising sun into their living rooms and their bedrooms to ensure that we are able to see what is going on behind the curtains and behind darkness. That is what we are about. So, Madam President, I have, based on what you have advised, I do not want to detain you any longer. You told me I have a few more, I think it's about a minute and a quarter. Is it that, Madam President? And I don't want you to rise and I fall. So I will want to fall with you the same time you rise. So I would want, Madam President, this time to thank you and to serve notice on the government that we intend to submit several amendments for its consideration, and we reject several proposals that the Minister and the Attorney General has put forward, and we look forward and so on when we come to the land adjudication bill to deal with the matter that I have raised in a more detailed way. But I have some more information to share with the Attorney General and the Honourable Minister, who seems to be a fighter against impropriety in that particular area of his operation. I thank you very much, Madam President.
Senator Creese.
Thank you, Madam President. I want to begin by giving credit where credit is due with regard to the attempt that the Attorney General is making to bring some clarity and to put an end to the problems that working people who are able to afford or to inherit land are experiencing in having their titles regularized. I myself have been frequently visiting the Registrar General's office in the attempt to have the same objective achieved. And as I speak of objectives, it is laudable to facilitate what is a centuries-old problem, the whole question of title of ownership and behind that, of course, is the broader question of agrarian reform, because we are part of a society that is transitioning from old feudal system of slave ownership and plantation economy. And as we move it to the 21st century, where the descendants of slaves and indentured people are coming into ownership or experiencing problems after coming into ownership, in that the system of laws we have, which are fairly complex, because you talk in terms of Trinidad and Tobago, which, though a Spanish colony, was largely developed by French planters from other parts of the Caribbean. So you have this problem of Spanish laws, French interpretations, and then the arrival of the British bringing another spin on it. And if we turn our attention to Tobago, it's even more complex with the several changes of European quote-unquote mother countries that have been responsible for the initial development of Tobago, in the plantation era. So that we have a complex system of laws that affect how land ownership is seen and conducted. So it is commendable that an attempt is being made to bring some order. But my concern is that this piecemeal approach brings with it its own set of problems in terms of the gap, the time gaps that exist between the initiatives that are being, undertaken in this particular registration of a titles bill and the other bills that we know that have been listed, and that they all collectively are trying to bring some kind of order to the whole question of land ownership and the recording of land ownership or adjudication over land ownership issues. And it is, my greatest regret that rather than coming here to face a collective piece of legislation which seeks to overhaul all that's currently on our books, that we are going to find ourselves in this piecemeal approach. And I'm wondering what are the traps that this is forcing on us, in that we are all aware of the complex number of issues that are lurking in the background of any kind of legal land reform. I mean, and we are talking here against having just dealt with the property tax, which has shifted the whole question of how one treats with the payment and the processes involved in the payment of property tax. I myself, in pursuing the registration of a particular title with the Warden Office, found myself last week being told by the Warden Office in Labrie, you can no longer pursue that here. You have to go to the valuation office at Point Fortin. And so there am I with big brown envelope full of documents. I done in Labrie already, so might as well go on to Point. And then there's a new process involved. Good. So there's upsides and there are downsides. And I would admit that one of the upsides in this is that in all the years owning different properties, I've never been visited by the Warden Office. In other words, I don't know to what extent they knew where the property was, and what's my physical relationship to it. And So that the good part of this is that I was told by the valuations office in Point Fortin that they would be visiting within a month or so, and they gave me a number that I can call if nothing appears to be happening. So that is the good part, because that was always one of my concerns. If I'm paying taxes and nobody is visiting, you know, whether the land is in the sea or whether the land still exists, good, and there's no requirement within the law for me to actually assert or be sure that the land has been washed away by the sea. Good. So I appreciate the benefits of that shift. However, the overriding concern as to all the nuances that are involved and whether this piecemeal approach would get us there, I have serious doubts about that and about whether the other listed bills to come would not end up the way it did, as the Attorney General referred to previous attempts having lapsed as Parliament moved on to deal with other issues or other bills, other matters. So that's the initial concern. But I appreciate, particularly in the case of Tobago, the attempts to put some order there, because the whole question of the sustainable development goals, which the previous speaker alluded to, the underlying issue is what little property the underclasses of our society own or have access to. This should be allowed to, they should be facilitated in whatever mechanisms the wider society has for development. Development based, of course, on the ownership of property. Because the whole question of the ownership of property is critical in the development of societies such as ours. As I said, we are largely a post-colonial, post-slavery society, and therefore the movement from being landless to land owning has to be facilitated by the legal processes such as these, amendments to laws such as these. And when one looks at all the critical pieces of legislation related to land ownership and registration of lands, we are talking about years 1884, to put it sequentially, 1845, 1884 with registration of deeds, 1892 with RPO, 1903, so that there has been, over the years, attempts to place order on the situation and therefore allow people who are transitioning from being landless, and Trinidad is largely a migrant society with people coming in from the other islands, so that in terms of having a stake in the society, it is critical that legislations such as these move swiftly to facilitate the acquisition of properties or the mortgaging of properties, because one of the issues I'm aware that farmers experience is that, and farming is largely critical to this issue, is that you inherit property from your grandparents and so on. And in the case of our Indo-Trinidad communities, particularly in the Southland, we are talking about the inheritances from crown grants that come on down through the years, and the cost of the transferring of properties from one generation to the other. And what I'm hoping for, apart from the facilitation of this in the processes outlined by the AG, what to me is missing is direct attempts to reduce the cost of the transferring of properties. Because this, to me, is also another aspect of the overall problem that this legislation seeks to effect. Because, and I mean no disrespect to the attorneys present, but the cost of having properties transferred is really inhibiting, and there are generations, especially within the farming East Indian communities, where these transfers really just do not take place until a crisis point is reached. And I'm not satisfied that what we are doing in this and the other related pieces of legislation addresses that effectively. Yes, in the case of Tobago, I can see how the land adjudicator aspect of it would bring relief. But for much of the agrarian, agricultural communities of the south of Trinidad, this is a very small step, to be quite frank. I would also like to point out that the whole question of squatters and provisional title is in fact an improvement, because there is a culture in the south and in the east where most of the available agricultural type lands are for people to erect homes over 2-day and 3-day and long weekend holiday periods. And therefore, given the high cost of lands in the urban built-up areas, there really needs to be initiatives that facilitate people who are tempted to squat. Good? And I don't think I have to go through the history of the legislations that previously exist, particularly in some of the other Northern Caribbean islands, but to a certain extent in Trinidad as well, which sought to prevent migrants, which sought to prevent the local populations who were landless from exiting the plantation sector. So it is critical in terms of what are the common Caribbean social problems and common Caribbean economic problems, which in most cases are one and the same. They derive from the same root, that we move to afford to quote-unquote squatters with some instruments of title that are bankable. Because in another place where we're a different cap, in the credit union movement, that is a critical issue, a critical humbug in advancing family-based enterprises, because of their inability to present to our funding, our financing institutions, certificates of title, deeds of transfer, and instruments of that nature, so as to form the basis of the financing of family-based activities, particularly agriculture. The thing is, though, especially with regard to agricultural development, I'm wondering if there's a sense in which we are almost too late, because there's a shift in agriculture from horizontally based agricultural enterprises to vertically based enterprises. But yet, I suppose if even you're on 2 lots, which will allow you a lot of significant development, the time when having large acreages was critical, that time has largely passed. Right? But they say better late than never. And on a small island, such as the one we have, land is, of course, a disappearing resource. I also wish to draw attention to the attempts to tighten up the folio system, but in the larger pursuit of having the records available, fully computerized, fully digitalized. I appreciate Senator Mark's point about whether we want to inhibit access, searching of documents, and whether that would really form part of a valid attempt to contain attempts at fraudulent activities within the system. I think at the end of the day, whatever we do, we should ensure that searches of title should be cheap, should be available, because we are in the digital age, we are in the IT age, and therefore that is the mechanism that we would all want to be available, especially to the children of parents who are freshly into a new literacy period. Many of us, our grandparents and great-grandparents, might have been illiterate. That's not unusual in our situation. And therefore, this new access, this newfound access to being able to read and to go wherever reading allows you to, is a critical part of the turn that our society is making. And therefore, I would want to advocate caution as to how access to registration documents is in any way curtailed. The other thing that I found interesting in all of this is that the facilitation of rectification of minor errors on deeds by mutual consent of the parties to be a very, very laudable move, because it would reduce the legal costs that would have involved if you had to go through the full-blown procedure, for one, and without really adding value to the property, simply adding costs. Right? So I want to commend again the AG's office for that foresight. Good. At the end of the day, Madam President, I think this is a good start. Good. And I wish to commend, the government for this initiative, and I hope that before this, before the parliamentary recess sets in, that we are able to go through the other pieces that are related to the whole question of, and in a broad sense, it's really agrarian reform. It's really about land and people being able to own land and making land ownership and land management a simpler process. Good? So I look forward to the AG's introduction of the other pieces, and when we return, I'm not too sure when we are taking the luncheon interval. Okay. But the only thing, the AG is not in the house, but I wanted to know to what extent the question of the Americans in the Maruga district are being afforded by the legislations, the pieces of the amendments and the other bills that the AG has proposed. Because to me, that is the other segment of our society that has been vastly denied enjoyment of property rights, properties granted by the Crown. We have the East Indian community, the descendants of the indentured laborers who were afforded Crown grants, especially the Rosilac and Faizabad areas, but, who would be able to benefit from what is being proposed. But there's an earlier population segment who came here after the British-American Wars of 1812, 1815, who were afforded crown grants, but who were unable to have these titles regularized and who are now into, well, 1815 to now 5-6 generations later, good, and who do not possess the kind of title necessary for bankable activities. And we are talking about sizable parcels of land stretching from Moruga to Rio Claro, just southeast of the Princestown area. And I have serious doubts that what is being proposed, certainly in the registration of titles here and in the others, would directly assist them in getting their situation rectified. So in that regard, I would have appreciated if any of the other speakers on the government side and, of course, the AG himself could guide us on whether their situation has been considered by this particular set of amendments or in any of the others, because it is one of the more underdeveloped areas, and to be quite frank, there is a link in that particular problem with the problem of the cultivation of that questionable herb. And as the song says, coming from Moruga with a trunk full of you know what. There is a reason for that, and the reason is that those people who own, quote-unquote, own those lands are unable to go to the neighborhood banks and or credit unions and prepare business plans for those lands. And therefore, they resort to more lucrative.
Senator Crease, I just want to caution you at this stage. I just want to ask you to look to the bill at hand and deal with the issues that can arise from this bill, okay?
Thank you, Madam President. So that I would leave it to the government side, if they are possessed of the information that would clarify that, to proceed with that. The other thing I wanted to draw attention to is that the particular provision, and I wanted to quote the clause, I think it would be it would be at 4, no, that would be 13, good, relating to the folio system, good, and the simplification of the whole question of the root system. That too is a commendable initiative, good, and that clause 13 combined with clause 14 does result in a better management of sorting out any nuances that may turn up sometimes with regard to the whole question of surveys and the resurveying of the lands, relevant lands, and of course in the development of these lands, sometimes the insertion of access to rare parcels requires some amount of modification of the details of the deed, and I see those two clauses as providing, an easy solution for that. So that too is beneficial, and the AG's office should be commended for that. And at the end of the day, and this is the point at which I wish to close, because Senator Mark had mentioned the question of sustainable development goals. I find that generally this piece of legislation has a focus on achieving security of tenure. And all the various things listed in the 17 or so sustainable development goals, at the end of the day, the question of people being able to feed themselves and getting away from hunger, security of tenure, and ability to develop whatever property you have, and is in fact being guaranteed in terms of the new approach to the registration of titles. So in that regard, I am prepared to support this bill. I thank you.
Minister of Trade and Industry. Thank you very much, Madam President, and it is indeed a pleasure to join with my colleagues today in supporting the AG on this very, very important piece of important pieces of legislation that are being brought before the House today. I mean, and what this again shows is this government's commitment to have a strong and effective system of land administration in place. And this is what we're doing today. I'm hearing some noise coming from the other side about this is a UNC bill. I mean, but I think if they had only listened to the then Prime Minister, former Prime Minister Bazir Pandey, I think they would have been in a better place than they are now. That's the problem. But anyway, the AG went into length, Madam President, to address the history of the registration of lands, and there's no way that I'm going to repeat any of that. But just to bring us up to date, this was passed already in the House on March 16, 2018. The entire compendium of land registration bills that we're starting off with. And it is expected that the independents and the opposition will give support to this important set of legislation. Again, this is just an amendment process into a bill which was passed since the year 2000, but which was never proclaimed and therefore hasn't come into force. So it's been a long time in the making, many years in the making, and of course it has taken the dedication and the commitment of this government to finally bring this work to fruition. And again, I congratulate not only the Attorney General, but all of the public officials who have worked on these pieces of legislation. So it's just one of what we're dealing with now, which is the registration of titles to land amendment bill. It's just one of a plethora of land reform legislation. Also today, we're going to go to full throttle on this. We're going to be dealing with the land today and finishing today, the Land Adjudication Amendment Bill, the Land Tribunal Amendment Bill, the State Suits Limitation Bill as well. And again, this all enjoins with the work that the AG has done previously and reinforces the legislation already passed recently, including the Property Tax Amendment Bill and the Valuation of Land Amendment Bill. And I mean, clearly, none of these pieces of legislation which we're attaching ourselves to today, or even that recently with the property and the land valuation, exist in a vacuum. And this is why perhaps we should have dealt with all of them in one and save the Parliament time and save all of us time in discussing the legislation. It all will mesh, so that at the end of the day, we will have a fulsome and proper land administration system. And the objective is really simplification, simplifying a very complex process which exists at this time. And it's a continuation of the land reforms that our PNM administration had started in 2008 through an IDB loan, whose purpose was to effect land registration on a compulsory basis. And this work, unfortunately, but not surprisingly, stopped in 2010. So absolutely nothing was done in between 2010 and 2015. Very, very important to note that I don't know what the focus would have been, but it may have been more self-serving and self-enrichment, if I'm allowed to say that. But absolutely nothing was done on land reform by the last government during 2010 and 2015. So, Madam Speaker, I've learned, I've listened. In particular, I want to go to the key elements of the bill, and then I can speak to the influence on the Ministry of Trade, the influence on the economy, and so on. So, the key elements, and the AG highlighted the fact that we are fixing land administration in Tobago first and foremost, and I wish to emphasize that and bring that to the attention of the public, especially to the Tobagonians as well. Very important to them. The system is chaotic and archaic, and once and for all, we are approaching this and dealing with the land administration fiasco that exists in Tobago. So speaking to the key elements, it's an amendment to a bill which was passed in 2000. This legislation provides for the registration of interests and estates in land, subject to the provisions contained therein in that register. When this legislation is properly implemented, there will be an up-to-date official record of the legal ownership of registered land, which will be overseen by the registrar and the land registry. And I will address the AG. Didn't have time to speak to the new registrar, and I will speak to that in particular. And again, this legislation is aimed at making the ownership and the transfer of land more reliable, more convenient, more stress-free, away from the complication of the existing system. The land title document, the land certificates that will be issued pursuant to the legislation, will serve as evidence of ownership to the exclusion of the world. To the exclusion of the world. Persons would thus be afforded a level of protection from adverse possessors and persons claiming superior title. Further, a proprietor or potential purchaser will now be assured that what is endorsed on the land certificate is indefeasible, and the need to worry about hidden defects capable of defeating title will be significantly reduced or may even be done away with totally. The AG would have dealt with the main provisions in the bill, and I would just speak to some of the provisions which he didn't have the time to attend to. In particular, the creation of the position of the senior assistant registrar, and so on, and the creation of the condominium folio. He mentioned that as well. The replacement of the term certificate of title with the term land certificate, the widening of the powers of the registrar, and so on, giving the registrar the powers to change the name and address of a proprietor on written application, prioritizing properly executed instruments, etc. So if you go to the definition clause, which is clause 3 of the bill, several definitions now altered are of importance. The new definition of encumbrance means a proprietary right held by one person over the land over another that limits the ways in which the owner may use or deal with land. The definition of condominium, now introduced, means housing consisting of a complex of dwelling units in which each unit is individually owned. It speaks to the land certificate issued under Section 24 and includes a certificate of lease. Speaks to the Director of Surveys, means the officer holding the Office of Director of Surveys referred to in the Civil Service Act, and of course the Senior Assistant Registrar. Now, clauses 4, 5, 6, 7, and 8 of the bill amends sections 5, 6, 7, 9, and 10 of the Act to include this post of the new Assistant Registrar, who will have considerable responsibilities in ensuring the proper implementation of land administration reform as it relates to registration of and recognition of title to land. Clause 9 will amend Section 13 of the Act, providing for the maintenance of a land register by the registrar and shall account for the folios of land that will be brought under the registered system of the Land Adjudication Act, and will include lease folios, condominium folios, interest folios, and now as well. Clause 14 will amend Section 30 of the Act to give the registrar powers of rectification concerning the register or instruments presented for registration. So the remit of the remit of the registrar has been expanded and in several ways, so that he now has powers of rectification given to him under Clause 14. And so what it means is that in formal matters and in the case of errors or omissions not materially affecting the interests of any proprietor, he can deal with that. In any case, at any time, with the consent of all persons interested, he can address those as well. Whereupon a resurvey, an area shown in the register is found to be incorrect, in such case, the registrar shall first give notice to all persons appearing by the register to be interested or affected by this of his intention to rectify it, and upon receipt of any decision of any court of the land tribunal, so that he has other powers as well to record a change of name and address of a proprietor in the register upon proof of same when a written application is made. No, but I am informing the public, and I am informing the public.
Madam President, on 46.1, could you guide us? The lady is repeating the honourable member is just reading the bill. Please, guide us on this matter, please. Yeah, God, man. I am going to jump up now.
Okay, President. All right.
Would like to jump up?
Yeah.
Who's he jumping up to the
May I now, Senator Mark? Thank you so very much. Minister and members, when we are dealing, this is a debate, so we can make reference to the different clauses without having to read them out. And, excuse me, let me just, please, it is either everyone in this chamber has decided today to do away with standing orders, or that you all have gotten very hungry from since 10 o'clock this morning. So please, all members in debating, you don't have to be reading each clause of the bill as you make your presentation. Continue, Minister.
Thank you, Madam President. It's just that the Attorney General didn't have the time to deal in particular with the scope of the work of the registrar, and this is the reason why I thought I would inform the public of it. But I will go straight to Section 20. I am relating to the bill as is required, and I will go to Section 20, where Senator Mark had some concerns, and he was concerned about he spoke about the fact that politicians will now be intrusive, and that the public were not allowed to go to the registry to make their searches. That was a major concern with him. And I want to speak to the actual legislation. I'm sorry, to Section 20, which refers to Section 73 of the Act, and Section 20C3, that a member of the public may in fact search the electronic records in the land registry. You can search electronically to inspect any portfolio or any sheet of the parcel index map or any instrument or plan filed or conduct an electronic search in respect of any parcel of land, so that the public has the capability of doing an electronic search. However, with regard to the physical documents, and therein lies the difference, that has to be done through an attorney and a search clerk, Senator Mark. And the reason for that is because there's a mischief with regard to the physical records being tampered with. That is a fact. And that is the reason why we have, and what I'm saying is, you can still search electronically, but when it comes to the physical documents, I repeat, can be done. I'd like to finish. The physical search has to be done by the attorney at law or the search clerk, and again, to cure the mischief which exists today. And so all that you're saying about politicians having ulterior motives and so on, that has nothing to do with that. So in practice, so I wanted to speak directly to that, but in practice, Madam President, and I'm hearing a murmur.
Please, if a member chooses not to give way, that is the member's prerogative. Yeah. Okay? Continue, Minister.
Right. So in practice, under the legislation, Information on land rights will be recorded in some form of land registry and cadastral system. Effectively, what we will establish in the construct of the law is a parcelized basis of registration, the use of a unique parcel reference number, the establishment of a priority for enforcement interests, the establishment of procedures to manage the land registration process, the maintenance of records, the establishment of procedures for compensating persons who suffer loss. The system, therefore, is going to be a lot more streamlined and more efficient in its operations, and that inherently are the advantages in what the approach we're doing now. So overall, it's an improvement in the land administration system in Trinidad and Tobago. So it's about land rights, it's about land use, it's about land valuation and taxation. All of those benefits are encompassed here. And as I said before, it is critical. Why this is critical is because land is special. There are no two ways about it. Land is special to young people, establishing a life together. First thing you want to do is to purchase a piece of land. To the businessman, land is critical. In the event that he, especially with regard to the collateralization of the land and his ability to be able to access loan facilities, to be able to expand his business and so on. And Senator Wademark did, in fact, and he will never be minister again. I don't think he ever was, but certainly he will never be. But Senator Wademark. But you have defined your future, Senator Mark, and I move on and speak to you. You have done it yourself. You have defined your future. So I was saying to you about the value of land and so on. The fact that it's a legacy item.
Madam President, I object. And I seek your protection. I am not you. Could you correct that, Honorable Senator, and let her refer to me by proper title?
Leader of Opposition Business in the Senate.
No, I am Senator Wademark.
Senator Mark, may I just say to you that, anyway, I shouldn't use local parlance here, but you see the crosstalk? The crosstalk is what is inviting some of these issues. Minister in reference to any member, senator. Continue, Minister.
And I'm sorry, Madam President. Thank you. So as I was saying, I want to bring us back to
You see what I mean, members? If you continue, Minister, with this talking to each other, then I have to constantly be on my feet, and I don't like it. Minister, continue.
Thank you. Thank you. I want to bring us back to the place where I was saying the significance of land in that it constitutes wealth, the significance of legacy, something that you leave for the next generation, the fact of the business persons and the whole question of the collateralization, which is important for the growth of business. So it is important to persons right across the Trinidad and Tobago. And one can well imagine how this has stymied the development of business in Tobago, where the land administration system is in chaos. It really has stymied the individual businessman into making progress, into expanding his business, into going to the bank with a land deed to say, here's my land, it's valued $500,000, can I borrow half? And so he's just not had that benefit. And it is too across Trinidad and Tobago, where there are many areas in Trinidad and Tobago, particularly in the rural areas, where people don't have access and don't have that land deed in their hand. And that is important to most persons. It's the reason why land is important. It's the reason why all people, everybody lines up to pay their property tax and will continue to do that, because it is special. Land is special. At the end of the day, overall, I can say this is all of this is part of our continuing effort to build the economy of Trinidad and Tobago, and indeed Senator Mark spoke about that. I can tell you about some of the challenges that we are having in the Ministry of Trade and Industry with regard to the question of land, the limitations of not having a proper land administration system. And when I look at where we are, for instance, on the when I look at some of the global indices, the ease of doing business, the global competitiveness index, where we are, and indeed Senator Mark brought these up, and I want to respond to them. We are being very, very serious about attaching ourselves to improving all of these indices, and so that we have embarked in the Ministry of Trade and Industry on a system of reform of all of these relevant indices where we have not been ranking to our satisfaction. So that I can tell you, with regard to the whole question of land reform, again, and I want to be very clear, the particular index of registering property, where we are notably 151st, not at all commendable, 151 on the list with regard to registering property. The last government was not able to do anything about this. We are taking this head on, and we are taking this head on, and therefore on the matter of registering property, there are several deliverables that we targeted to be achieved, including the development of a checklist for attorneys and property owners, and the amendment of the Registration of Deeds Act, Chapter 1906, to increase the penalties for contravention of the Registration of the Deeds Act, as well as the Real Properties Act in cases of proven fraud, to review and approve the proposed amendments in consultation with the Chief Parliamentary Council, to expand the authority of the Registrar General in respect of the registration of common law titles by amending the Registration of Deeds Act and the Registrar General's Act, the amendment to the Registration of Deeds Act as well as the Registrar General Act. All of these deliverables we have taken on board, and many of them, I can say to the population, we have in fact achieved, so that we are well on our way. And I can tell you, perhaps not by the next publication of the ease of doing business World Bank rankings, but I can certainly, which will be in 2019, but I can assure you, but by 2020, we will be well ahead, and our ranking will be way improved. We will be way improved with regard to this whole registration of property. We are taking this thing very seriously, Madam President. And again, with regard to the automation of the one doesn't stand alone. So we're talking about registration of property, but again, the construction permitting process. Pretty soon, by next week, we will announce our pilot project for the automation of the construction permitting process, which will involve business process re-engineering, upgrading of hardware infrastructure, automation of the workflow process, digitization of all our maps, capacity building, public awareness, and so on. And this all intertwines with the registration of property, so that the consumer, the citizen out there who wishes to get his land in order and proceed to building on it, and he will in fact be able to do so through the land registration reform and also through the construction permitting reform as well. So this government is well on its way to making it easier for the citizens. And also, a significant reform is also taking place with the single electronic window again. And but I will not go into any details for fear that I will run afoul of the rules. But again, I want to speak of the difficulty with investments. And overall, one of the main goals is that is so that there is certainty and predictability with regard to land and land administration. And there are issues. I can tell you, if I can cite an example, with regard to the Mitsubishi plant, which they are well aware of and that they were involved in under their administration, but which we had to come in and refine and redefine to ensure that it actually takes place because of some negligence on their part, but I will not go into any detail about it. But I can say to you that with regard to the construction of the highway, north to south, the Solomon Hochar Highway, all of these, you'll be surprised, these were not captured in the survey plans. So it took us more than a year to unravel and to be able to move forward. Therein lies some of the difficulty. I can tell you, with regard to HDC housing, many a time the question of the vesting of the land is delayed years because of land issues as well. And of course, that also delays the granting of the mortgages and the citizens' right to own their property. So therein lies some of the bases for which we must proceed with this land administration reforms, if I can call it that. I mean, in cases of compulsory acquisition, you seem to...
Honourable Senators, at this juncture, we will take the break and we will return at 2 p.m. So this sitting is suspended until 2 p.m.